On today's episode, we talk about the two class action lawsuits, Burnett versus NAR and Morrill versus NAR, as well as a couple other brokerages. The details on that, what the outcome might be, what the future of real estate looks like, and what you need to be doing to prepare for some of these things that are coming down the pipeline. You talk about it privately, we talk about it publicly. This is the Real Estate Insiders Unfiltered podcast. Welcome again to the Real Estate Insiders Unfiltered podcast. I'm your host, James Twiggins, along with my co-host, Keith Robinson, aka Crazy Uncle Keith.
Yes, sir.
Keith, tell us about what we are covering.
Oh, today we are going to have the great and powerful Rob Hahn, the notorious ROB, on our pod.
Got to check out his blog. It's pretty amazing.
Pretty amazing. Lots of words, many words.
You have to be able to read extensively.
Yes.
So.
And we'll be unpacking the lawsuits. There was a big announcement recently that one went class action. We'll be unpacking.
Morrill, yep.
Yeah, telling the story about what happened, how we got there, and then Rob, we'll ask him what he thinks is going to happen. And won't be good news. I guarantee you. It never is with that guy.
We're looking forward to hearing all of his take on it.
Yeah, it'll be great.
All right, Rob, welcome to the show. We are super excited to have the one and only Rob Hahn on our pod. There is no other person on the planet like Rob, and I am excited to get this thing kicked off and hear Rob's take.
Me too. It's so cool to be a guest on somebody else's pod. That's actually really neat. And let's be honest, there are a lot of people who are super happy that I am the one and only. Could you imagine there's two people like me running around? Holy crap.
That would be a lot. So Notorious Rob, by the way, is if you don't know his blog, you should go check that out. We've got an AKA Notorious Rob, and we got an AKA Crazy Uncle Keith on the pod. So
every family's got one.
Why do
I feel like we should all have glasses of bourbon in front of us right now and maybe a big cigar?
I'm not saying no.
Except it's only 3:00 here still, and it's maybe a little bit early to set.
I mean,
set
what James said. What James said. Yeah.
All right. So here's the deal. We invited Rob on because Rob always has a point of view, which we love.
Yeah, we call it the positivity half hour.
I'm white-pilled, bro. I am so white-pilled.
There you go. But here's the deal. We have Rob on for a very specific subject that he definitely is one of the more educated people on these topics. We'll have a little bit of conversation about it, starting out with what these class action suits are that are in residential real estate. Rob has written extensively about it. I follow what Rob writes. I follow a lot of what people write. But Rob is also, what makes him unique is he is a former lawyer, so he has a background in understanding the law a little bit better than most people do, which makes him dangerous.
Does that make him a recovering lawyer, or just
is that what you call it? Where did you go? You went to
Yale,
right?
I went to Yale undergrad. I went to NYU for law school. I summered and I decided I don't want to do this. So I am a member of the New York bar, but I'm retired and I never actually practiced law. But I do enjoy the hell out of reading law cases and legal briefs, which is just a character flaw.
Yeah,
what can I
God
say?
You do. Somebody needs to. I've been to a New York bar. Is that the same thing?
It's very similar.
Very similar.
You've been to a lot of those, Keith. I've been present on some of those excursions.
That's a fact.
Rob, all right, here, start us out. Give the listeners and the viewers a little bit of. Talk to us about the two major class action cases. You can venture into the DOJ, bring it down to the level that Keith and I can understand and everyone else. And then we'll dive into what you think about all of this stuff. So let's start there first.
Sure. So fundamentally, like you mentioned, I've been following this since March of 2019 when the Morrill lawsuit was filed. That was the first big major commission lawsuit. That's what I've been calling these, right? Okay. The second one is out of Missouri. That's the Sitzer, now called Burnett. So there are two big class actions. Morrill's the big one, and then Burnett is only within the state of Missouri.
Missouri, right.
Fundamentally, what the claim is that the practice of cooperation compensation, where the seller pays the listing agent, and the listing agent shares that commission with the buyer agent, right? Mm-hmm. The fundamental claim is that is anti-competitive. It's a violation of Sherman Antitrust Act, right? And that as a result, it keeps commissions way high, right? That's the claim. Now, there's a gazillion legal things about conspiracies and this and that, and forget all that shit, right?
And the defendants in this are, the defendants are who in these cases?
The defendants are NAR, the National Association of Realtors, and the 4 corporate defendants, which are 4 of the largest real estate companies. It's Realogy, now Anywhere, Keller Williams, Remax, and Home Service America.
Okay.
Along with obviously BHHS, which is their franchise brand. So,
And
when this was
Burnett's in
first,
Missouri. Burnett's in
Burnett's
Missouri
that's right. So
specifically.
Burnett is essentially an exact copy of the Merle case, but it's just in Missouri, and just claiming that those 5 same defendants right, did this to the people in Missouri. There's some state law claims under Missouri, but again, it's not completely relevant for our discussion. The fundamental claim is the sellers paying the agent, and then all of the practices around that is a violation of that Sherman Antitrust Act, and therefore the sellers or the plaintiffs are owed money.
Okay.
That's 1. And 2, that this practice of allowing the commission sharing should be banned, basically. That the court should say you're not allowed to do that anymore. In as simple a layman's term as possible, that's the case. Now,
All right. Go deeper.
in the beginning, it was assumed, I think the industry heard it, whatever, NAR, MLS get sued all the time. Who gives a crap? I remember saying, no, this is different because of the law firms that are involved in the Merle case specifically. Right? Cohen Milstein and I think the other one's called Higgins Berman are not your typical run-of-the-mill ambulance chasing green mail artists. That these guys go after like Visa, Amex, Big Tobacco, Big Pharma. I mean, these are like the best of the best in terms of the plaintiff's bar, is what they call it. Like
Unlimited funds, massive law firm with tons of money to throw at the case. Okay.
Not only that, but like, you know, if you look at their hiring, like you don't just go get a job at Cohen Milstein. You know what I mean? Like you are among the best litigators in the country, you have tons of experience, and they make hundreds and hundreds of millions of dollars from these lawsuits. Why? Because when you do one of these lawsuits, you know, as a movie like Aaron Brockovich told us, you might do it for free in the beginning, but when there's a settlement or a judgment, you're going to take 30 to 40% of that.
Right.
Right. So you do $1 billion settlement, guess what? Your take is 400 million. And, you know, so in the legal community.
The point you're making here is that these firms don't take on cases that they can't win. Is that fair?
Correct. Because it's a big risk for them. It's a large investment for them to take it to either, you know, settlement or trial judgment. And I thought these 2 guys are not your run-of-the-mill lawyers. This is very serious. And I think events have proven that I was probably right on that call. So because the thought was they're going to get it dismissed. You know, like, what are you talking about?
Right.
There's a contract between the seller and the listing agent. Who cares? It's so... Long and short of it is there's been a whole bunch of motions, right? Motion to dismiss, you know, motion for class action certification, all these different motions. That's very normal in complex litigation. And basically the plaintiffs have won every single motion. Not only that, but the judge's opinion on ruling on these motions essentially makes it obvious to me that at least the judges made up their minds. In both cases, both Merle and Burnett, right? In addition to that, and I think this is a relevant factor, in both cases, the United States Department of Justice intervened in both cases with neither for the plaintiff nor the defendant, but their intervention happened to chop the legs out from NAR, one of their key arguments in the beginning. So it's pretty clear that the government has a thumb on the scale. So the latest kind of brouhaha that is leading to this conversation is Burnett was already classified as a class action. This part's really important, right? Because if you're NAR, if you're Keller Williams, right? If you're defending a lawsuit against one guy, one seller saying, hey, you screwed me through this thing. All right, whatever, right? You know,
There's
fine,
legal
$30,000 damage.
Sure.
Here you go, right? When you become a class action, now that one guy can represent everyone who's ever sold a home.
During a period
and
of time.
now it gets crazy. So they fought that pretty hard. Burnett, they already lost. Burnett's class action. That thing is going to trial in October of this year.
Right.
It was actually supposed to go to trial in February, but they delayed it. There's been some so now it's pushed off to October. Merle is the big one, is what they were really fighting class certification on, and they just lost that. So the judge just ruled yep, I'm going to allow this as class action lawsuit. So now they can go and, recruit a whole bunch of people, right?
And it was anybody who bought a house between 2015 and 2020, if I remember my math correctly, in 20 markets across the U.S., 20 specific markets and MLSs across the U.S.
That's right.
And the damages potential on that?
I think I calculated the damages at roughly $195 billion.
So small.
So
number.
obviously.
So chump change, really. I mean, And then would it
basically
expand to other cities, or like if you weren't in one of those MSAs, or you don't get to play?
We're gonna get to that, Keith.
That's the scary
that to
part.
me is the real danger here. So yeah, obviously.
But I want to add one thing, Rob, real quick, because I think this is important. What's stemming this is two decisions that have occurred. And I want to be fair to NAR in this. Two different decisions over two different periods of times for two very different reasons. So, and I'm going to simplify, and if I'm wrong, correct me here. But you've got essentially broker co-op. Essentially, if you're in the MLS, you need to offer compensation to the other side of the transaction, to the buyer's agent, essentially. And clear cooperation policy, which is really where this kicked a lot of this off, which is if you, I mean, I'm attaching to, maybe I'm off, so tell me if I am, but you have a requirement for cooperation, and you now have a requirement that states if you're part of the MLS and you have a listing, you have to put that in the MLS within 24 hours, versus where it could have been, it was what do we call these, off-market
pocket
listings. So to me, I'm looking at this going, very different intentions and reasons for doing this. And to be clear, I'm not opposed to clear cooperation policy as adamantly as others are. I think that that's a whole different conversation. But the point is that it's a whole different conversation. But the point is that you have a policy where you have to you're required to provide cooperation, and now you have a policy that says everything has to go into that MLS where that's required. That's where from a plaintiff's perspective, that's a very solid argument to stand on, going, look, the people that are making these decisions are the very ones that benefit from these decisions. Am I off on that?
It's not that you're off on it, but I'll say that there are two other cases where they're really going after clear cooperation policy. And it's pretty clear that the Department of Justice and the FTC are very concerned about clear cooperation policy.
Sure.
But the two big commission lawsuits, Merle and Burnett, really don't deal with clear cooperation. And their claim is much more fundamental, right? Their claim is that the industry, NAR, through NAR, which controls all of the MLS policies.
Sure.
And that these four corporate defendants, those four were chosen not just because they have deep pockets, but because the plaintiff's lawyers have a lot of evidence showing that big-time executives at those brokerages served in some big-time committee positions and big-time leadership positions in NAR. Do you know what I'm saying?
Yeah.
So
sure,
they could weave this story that, I can't remember, like the president of NAR came from Remax, and then the next president came from, Home Service America.
You're tying stuff together, essentially.
Right.
Yeah, and that's the story you're going to lay out.
That is the story. And
is the issue, so I want to make sure, because people, I talk to brokers all the time who are just like, and I'm like, no, because this is going in front of a jury. Right. And that jury could be homeowners who might have paid a commission, right?
That could be.
Will be. Most likely will be.
So, but that's why I'm kind of like, it's not, there's no longer, we can't lobby our way out of this anymore. This is in a completely different realm of, we can't get a senator to throw the thing out. I'm making that up. But the point is, like, this is going to a jury of peers who will make a decision based upon the arguments plaintiffs' lawyers present versus defendants. And what you're saying is they would have not done this if they didn't have a clear path of evidence to show a very good story to a jury. Is that
no question?
Fair? Yeah,
no question. Now, let me provide a little bit of additional context, because you look at some of the commentary and social media posts and all this stuff since 2019, and there are a lot of agents out there making all sorts of arguments as if they're arguing to a court, and I'm like, just save your breath. Like, your opinion doesn't matter. Like, my opinion doesn't matter. It's what the law says. It's what the lawyer is going to argue. But in that context, I think it is important for us to at least consider the very first antitrust lawsuit that I'm aware of, that I've been able to find, is a 1950 Supreme Court case against NAR. At that time, it was called the National Association of Real Estate Boards. It wasn't even called National Association of Realtors, where they alleged exact violation of the Sherman Antitrust Act for keeping commissions high. At that time, what was going on was the NAR would publish, and then the local association, the local MLS would enforce a standard commission rate. And it would literally say it is against the code of ethics to charge less than 6%. So
Oops.
that one was
So
like
they lost.
clearly
They lost
they lost that one.
Yeah.
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 They lost that one. So after that, though, what NAR then did is it's not required anymore. It's not mandatory, but we're going to recommend, like a MSRP.
Sure.
Our recommendation is 6%. That got thrown out. That got sued. That got thrown out. So now it's okay. We're not going to talk about commissions at all. And the issue is here we are in 2023, and you look at commission rates across the country, and you know what? It's it's pretty close to what NAR first mandated and then recommended for over 70 years.
Yeah, I mean it's
come
lower
down.
than what's
It's lower
public
than
for what
that,
it's worth.
right?
I mean, 2020 it was 4.94 on average, but your point's valid. I just wanted to. I actually have some of these stats from Real Trends, so I can see that. But commissions have come down a lot since 1991 and further back. But
so that would go to the final factor that I think is relevant for our discussion, and this is a point that I've been making more and more over the last year, maybe 2 years, is a lot of us, I think, in the industry make these very detailed, very sort of technically true, correct, like these types of arguments. I'm like, look, what you have to understand is this is happening because the elites in our society, policymakers, the media, academics, think tanks, all of the people who kind of make up the elite leadership of the country, fundamentally think that we are paying too much for real estate services. Because they look at other countries, Germany, Europe, Japan, like all these other countries, say in those countries, the transaction cost for real estate is like 2%. Why is it 6%, 5%, whatever it is, right? It's so much higher in the US. Oh, it's because of NAR, it's because of MLS, it's because of this cooperation compensation thing. My take on it is, as if you just take a huge step back, if I'm a think tank, if I'm an academic, if I'm a policymaker, what do I want? I want real estate costs to be 2% in the US. How I get there...
Where'd you get the 2% number? Just because of what you're seeing?
That's sort of the average across the Western developed
I understand.
countries.
Okay. I just was trying to figure out where you got the number from. So okay.
It's like, yeah, we can make all these points, et cetera, et cetera. All I'm saying is be aware of the fact that all of the sort of leaders in our society, in our country, would like to see commissions be 2%.
You know what's interesting about this is that we have another guest that's going to be on the show, and I've had some conversations with him. He did a survey of consumers recently, asking them questions about their compensation with their realtor, and it was fascinating statistics. It was like a third of them don't actually know what they're paying, but when they actually disclosed what they were paying, and they went, this is what the realtor made on this, and this is an approximation of time, et cetera. The result was they didn't mind. And it was a large sampling of people. It was a significant sample survey.
This the 1,000-watt study?
Yeah, exactly. You know exactly what it is. Yeah. So it was really fascinating to go through that and see that study and go, that is really interesting, because we can get off on a tangent here because I want to get back to the subject. But I think there's what people want, and then I think there's an element of perception that there's a deep understanding that this is a complicated transaction. It's the most important transaction people mostly do in their life. It's the most expensive. I hate the idea of people thinking you can just do this with a piece of technology, because it's just not that simple. And where we end up, I think that's maybe a good segue. Where does this go? So our current industry, here we are pretty much the same way, to your point, we've been for a long period of time.
Yep.
And this is going to take time to solve all these. Burnett goes to trial in October. And, the Morrow case is going to be a good, year or two before it goes to trial, probably. And then there'll be an appeal. And then that appeal goes, Trump was going to try to go to the Supreme Court. And where does this go? And then give us and for the viewers and listeners, Rob and Keith and I are going to be probably in slightly different camps on the end result of this, which would be a good conversation. But then tell us where you think it's going to go. So
legally speaking, I don't think this gets decided for probably 5 to 7 years.
Okay. That's
right.
The full run, all the way up through appeal and
all the way, right. Supreme Court, whatever, right? I think if the Supreme Court takes it, then it's 7 years. If they deny cert, which I think they will, it'll probably be 5 years.
Be over in 5. Okay.
I think that's when we can expect that. Thing is, that's not the real problem.
Yeah, I knew you were going to go here. Mm-hmm. Yeah.
The real problem, and I've been talking about this now on my latest podcast, I think with Greg, I talked about it. I've written about it, and I'll talk about it here as well. The real problem are the copycat lawsuits. And this is the point that Keith brought up earlier.
And we all agree on this, by the way.
Right.
So,
which is, okay, look, the defendants are NAR and those 4 companies, and it's those 20 markets, right? I'm okay. Once it gets to class action, and certainly after after Burnett gets decided,
Mm-hmm.
right? Which will be, let's say, November, December of this year, right? Certainly after that decision comes down, you just have the plaintiff's bar going, there's gold in them hills, right? And Greg and I talked about it in our last thing. It's like,
assuming that NAR loses, to be clear. If they lose...
right. And
if they lose
at this
Burnett,
point, I'm saying they're going to lose.
Yeah, I get it. So you're assuming you're of the opinion they're going to lose, and then you're saying copycat lawsuits of like, wow,
Correct.
Look at all the other people we can sue. Let's go start a bunch of other
Correct.
class action, and here's the precedents to prove those suits.
That's right. Because, look, lawyers are like everybody else. If somebody else did the work and all they have to do is copy, paste, right, and start filing lawsuits, that's exactly what they're going to do. And at that point, the issue is going to be, and I think I brought up like Chicago as an example, right? Because Chicago is not named, MRED is not named. Cool, I'm some lawyer, I have 5 lawyers in my firm. Okay, I'm going to go sue MRED. I'm going to go sue the Chicago Association of Realtors and maybe 5 of the largest brokers in Chicago, right? That's what I'm going to do. So, Chicago, that's Illinois, so okay, fine. It'll be Topeka, Kansas. It'll be Grand Junction, Colorado. They're not named. Okay, cool. Let's go sue the local association, the local MLS, and the 5 largest brokers in this market. And sure, it's not $100 billion. We'll sue them for $10 million. All right, well, none of those guys could pay $10 million in damages. And I'm saying even before you get to the damages thing, if you get sued, and you know this, James, you run a company.
I get it.
You have to defend it, okay?
The cost of defending is massive on anything.
Exactly. Yeah. You have to have lawyers. You have to do all this shit, and you got to get deposed. You got to answer interrogatories. And I think my issue with the industry is almost no one is thinking about that piece. Like the process is a punishment. They're worried about, we're going to lose or we're going to win. I'm like, forget losing and winning. Start with, you're going to get sued. And then whatever you had in your legal budget for 2024 is not enough. That's the first thing I want to sort of put out there.
I'm assuming E&O policies wouldn't cover something like that either. I'm actually just pontificating here. So
it turns out I just actually got a comment from an MLS attorney. He said, look, E&O covers the legal fees. It does not cover damages.
Right.
And it doesn't cover settlements for antitrust. So
right. So basically, where it goes,
of your legal costs.
Sure. So legal fees might be covered if you have an E&O policy, and then, but to your point, damages and settlement amounts would not be, and you've got to come up with the money. And to your point, and we all know what the industry is. They don't have.
So you think you think that the plaintiff will win?
Yes.
Then you think all these copycat lawsuits are going to get filed, and then it's just scorched earth, like everyone that is in residential real estate goes bankrupt, and
pretty much.
What's the outcome? That's it? End of days?
I think all brokers that are in existence today probably are facing massive liability, except the small ones, because the small ones aren't worth suing.
Won't get sued.
Right. But like if you're in the top 100 brokerage today, I would be having conversations with my GC. I would have conversations. Hey, what's our legal budget? Where are we active? What's going on? And you have to confront the fact that you're probably going to get sued for your past activity. Right? In other words, there's nothing you can do today to escape liability when...
No, right, from the past.
Right.
No.
Yeah. What you can do today is to minimize liability going forward. Right? Like don't pile on liability.
What do you think that answer is?
Yeah, I think there's a bunch. And then we can get into that. Let's just make sure we cover.
Yeah, let's. I want to. Yeah, let's.
Well, no,
so
we covered
basically,
it. The world just ended.
the world just ended. I'm trying to. Before we dive into where you think things are going to go, and we'll get into that discussion because I want to.
Yeah.
So you think that this whole domino effect starts once Burnett goes down, and you're of the opinion that they will lose, and then once that happens, the lawyers will look at it and go, well, that's an easy thing, let's just go tackle everybody else. And it doesn't even matter. This is the part where I hate to agree with you, Rob. It's just my experience with lawyers. It's the truth. It doesn't matter whether you're right or wrong. The fact is you can get sued for anything and they'll do it because they know the system, and it costs tons of money to defend it. Do you think that there'll be some, let me ask it this way. There doesn't make any sense to sue if everyone goes BK because you get nothing. Not nothing, but you get almost nothing. So is there some larger settlement that occurs so that there's some money that's garnered out of it instead? Because I know from, not to sound like an asshole here, but like I know from suing, if you're suing somebody and there's not a lot of money there, the legal fees can cost more than the benefits from doing that. So my point is there some other way out?
I think the only way out, this to me feels a lot like big tobacco. Right, so remember when the whole tobacco litigation was happening? What that ended up involving were the 50 state attorney generals plus Congress. Like literally passing legislation and crafting this like national tobacco settlement, vehicle. I suppose that's possible. I suppose, but I don't know. That to me feels like entirely too speculative. It's really hard to say.
Well, I mean, can we pontificate and say that taking down residential real estate would be extraordinarily bad for the U.S. economy?
Well, but here's the thing. When you think about it, it's not actually going to take down residential real estate. So one of the things I've maintained forever around all these lawsuits is that the individual agent on the street is not affected by this. Not directly. They're not going to be sued, right? No one's going to sue Susie.
Well, the brokerage
agent.
Is sued anyway. The brokers is
the
obviously
brokerage would be out of business. Okay, fine. So you sue a brokerage. They're out of business. They're belly up. They're BK. Okay, all those agents are still around. They're still licensed. They'll just go work for another brokerage, or they'll start their own brokerage.
Start up a new company essentially that's fresh, that doesn't have any stuff from the past, and we move forward.
Exactly.
So I wanted to make sure that we all didn't want to like kill ourselves on this pod today.
Correct.
So
correct.
Yeah.
Correct.
All right.
I mean, the impact on the agents has less to do with that and much more to do with the fact that now they run into a different problem, which is convincing your buyer to pay you.
All right. So the idea behind these suits, to your point, just I want to reiterate for the listener and viewer again, is that the end result is they want buyers' agents to be paid by the buyer and sellers' agents paid by the seller. Just
that's right.
I'm really simplifying here, but that's essentially what the future of what they want this to be. Okay.
That's
All
right. And under the current structure, that's a real problem because buyers, I mean, and you guys know this, man. It's hard enough to get agents to.
Yeah.
Well, and that's exactly right. But it's hard enough to get agents to go talk about getting their buyers to sign an exclusive buyer agency agreement. Now you got to have them go talk. Not only do you have to sign an exclusive buyer agency agreement, you have to convince the buyer to commit to paying you, like potentially tens of thousands of dollars.
But why does it have to be the buyer that pays it?
Because if the losses, you know what I mean? If the seller's like,
but if a seller wants to, like, if I own my home. And if the only way I can sell it, or if I have the ability to sell it faster or get more for it by paying the buyer's fees, I would do that. They can't stop me.
Sure.
Right? So you could have a buyer-broker agreement, and I, as the seller, could agree to pay the buyer's agent.
You could.
Because I get more. Otherwise, the buyer can't afford to pay it. They usually are digging as deep in their pockets as they can for their down payment.
Without that also being potentially financed, which is a thing NAR should be working on, is
so either
legislatively changing things so that you can finance the buyer agent commission into that loan.
Yeah. So either the financial industry has got to figure it out, or we just end up at, isn't it possible that we just end up at every state runs like North Carolina, where you've got a requirement for disclosure, which, by the way, I think is the right way to do it. I think it is odd that it hasn't been disclosed before. And so long as everybody knows and everybody's cool with it, like, this could just be national buyer broker agreement, right?
So two things about that. One is that it could be. I mean, that's who knows.
Sure.
But here's my thing. I'm saying before you even get to that point, let's just say you're right, and a lot of sellers voluntarily would be like, "Hey, I really want to sell my house. You know what? I'll offer to pay your agents, commission." Okay. Thing is, as a buyer agent, are you willing to take that risk when you're working with a buyer? Because, in other words, those things are no longer unilateral offers from all sellers, all listing agents in the MLS, right? That's case by case. Some sellers will offer it, some sellers won't,
Sure.
right?
But
So from a buyer agent, right, you have to then go to your buyer and say, listen, some sellers are going to offer to pay my commission, which case you don't owe me anything. But if they don't, you owe me 2.5%.
So historically, the government is interested in home ownership. They understand that that's why you get a tax break for it, right? So the government wants people to buy homes. The government
Yes.
does not want to make it harder to buy homes.
Agreed.
So, and requiring the buyer, the cash-strapped buyer, to pay the agent fee would reduce the number of people who can buy homes. Period. End of story.
Sure.
Right?
Well, no, not necessarily.
Well, either you've got to find a
necessarily.
solution. Why?
No, what I'm saying is the other option is you just don't use a buyer agent. That's like all of Europe.
So people would just do it unrepresented.
Yeah.
That is worse than.
I'm not saying it's worse. I'm just saying if I'm the government, it's like
I was
wait a
going to
minute.
interject, but I was waiting for Keith to say what he was going to say before I did.
Yeah,
So,
no,
yeah.
I'm just if I'm the government, it's like what do I? It's not about you can't afford to buy a home. You just don't have to hire some agent
So-
to help you.
Rob Hahn believes that the government is going to require less oversight. Come on, that's crazy. That's not going to happen.
I don't know why we would equate to that, right?
Well, because I don't think the government is going to want a structure where buyers are doing it unrepresented. Now, it might increase dual agency. Okay, maybe that's possible, but I also think that's a problem.
Which is
Well,
a whole
let me
other
ask you
problem.
this. So if I'm the government, right?
Yeah.
So let's pretend that I'm some congressman. Oh my
Yes.
God, I'm disgusting.
Yes.
I'm a
I was
vile
going to
animal
say I
now.
would never vote for. Well, maybe I would vote for you. I'm not really sure,
But-
actually. Yeah.
So you're gonna say, hey, but whatever this, you just made your case. I'm like, well, Keith, I mean, what's the problem here? The buyer can just work with the seller and the listing agent. The listing agent is not allowed to commit fraud. The seller has to make all these disclosures. What's the problem?
Then you're right back where you were before, where you've got the seller paying both parties, right? So, like, why'd we go
the
through all
seller's
this?
just paying. What I'm saying is, buyer
You said there's no
unrepresented
buyer's
buyer.
agent.
What's the harm? Like, how did they get screwed?
So, do I have an agency relationship? Am I doing this dual agent?
No.
No.
It's just like walking into a car dealership.
Yeah, but that most people, this is the biggest financial decision that they're going to make in their lives. Most people, we've spent
Okay.
more time around campfires seeking
No,
wise
I
counsel.
get it. No, I get all that. I'm just asking you, what is the risk to the buyer if they are unrepresented and they are buying a house from a seller and a listing agent who are, like the law says, you have to be completely disclose everything. Do you know what I'm saying? You can't defraud the buyer.
I get it. You're simplifying the process a little bit in that the buyer's agent's
Of
going to
course.
be telling them a lot about the property, the area, what it is, what the risk, what's the appreciation, the things that. What I'm not, to be clear, I totally get what Rob's saying, and I'm not arguing your point. I'm saying that the customer, and I'll make a very valid point here. People have chosen in this country and continue to choose in this country to have representation. They're saying, I want that because based upon every company in Europe that's come over here, I'll go really back and date myself. Foxtons was the 1st, came over, failed,
remember.
bankruptcy. Purple Bricks came over, failed, bankruptcy. My point is, the customer in the United States is saying, I don't want to do this on my own. I want somebody to help. In fact, based upon the study I just mentioned
Sure.
with 1000 Watt, they're saying we don't actually mind paying for it. So
Sure. Then pay
I'm
for it.
I'm not just arguing the industry because I'm in it. I'm saying that if I think about it today, when my mom bought her house,
Yeah.
we had an agent represent her. And that
Yep.
disclosure package was 126 pages, Rob. Welcome to California. And who in their right mind is going to have any idea what any of that shit is in that 126 page disclosure package?
Yeah.
So I don't think the end result that's positive necessarily. I'm not arguing where compensation might change. In my mind, I think the way this industry is better represented, and I will go on record as saying, I do fundamentally think our industry will be better with the right things in place, if buyers agents are asking the buyer to pay them and are articulating their value clearly and professionally to do that, and sellers agents are asking the seller. Now, the way I think that needs to happen is partly with Keith. I think that there needs to be buyer broker agreements. We should be doing that anyway.
Totally
should be.
We should just be asking people. If you can't ask them to work exclusively with you, then you just shouldn't be in this business. Like, I don't do work for free. You shouldn't either.
Well, and everyone should know who's their
totally
gladiator
like
in the arena. Or
my
whatever.
fiduciary is with you, and I'm a big. I hate dual agency. I'm also very vocal about that. You can't represent two people without having a bias. The second thing I was going to say, and I'm segueing, Rob, because I want to talk about this, is second thing is I think NAR needs to work on figuring out how we can finance that commission into the loan, so that you can talk to a buyer. The commissions are negotiable. You work through that, and there's an easy path for a buyer to be able to say, I want you to do it. I don't have X amount of money to pay out of pocket, but there's a way to make that happen so that it's easy to do. The third, which I also agree with, and let's talk about auctions, because I think there's some interesting.
Before you talk about auctions, like that was my point. NAR doesn't actually have to go do any of what you just said about convincing. I've already figured it out. I have the solution.
So Rob, welcome to Decenture. So let's talk about what you've been working on. Yeah.
So the solution is a new company I just launched. Well, I launched it a year ago. I've been working on it like a madman because startup life. But I basically just announced it, and the answer is you actually should just do it through auction, right? Because it turns out you don't need to change the legislation. Auction buyer premiums are financeable under Fannie, under Freddie. I don't know about Ginnie Mae. I don't know about VA loans. There's probably some details. But all of those can be wrapped into the mortgage, so the buyer can finance that. And those are buyer premiums. So what I've created, Decenter, DPX, is essentially an auction platform where there's no commission. Instead, there's a buyer premium, and the buyer pays it, finances it, to us, the auction platform, because that's how auction platforms work. Every auction platform charges that. And then we, as the platform, will pay the agents involved. So we will guarantee compensation to the agents. The buyer can still finance. The seller gets true market price. There are lots of benefits to auctions, but that's probably a separate show, right? Like I believe in open auctions as the way to buy and sell real estate. But again, whether you agree or disagree, that is clearly one way to achieve everything we need to achieve.
And it's transparent because I've seen, to be full disclosure, I also am aware of Rob's project and have been helping a little bit behind the scenes on it. So transparency into what's happening, which is a great thing about auctions. That's everything is there. And also, just because I'm pretty sure I have this right, is auctions were excluded in the class actions. Right. And so that's correct. So
that's
it was
the
actually carved out by the judge.
Right. And that's why I ended up having to announce, because the judge literally says the class includes everyone who sold a home between 2015 and 2020, except for children of the judges, lawyers involved in this case, people who sold something less than like $33,000
or something like that,
$56,000, and if you sold at auction. I'm like, well, I think the judge just gave my company like triple the value of my company or something, because holy crap.
So you're an auction. So to be clear, I'm going to simplify here just for time's sake. We got to wrap up the show in a second, but you're basically an auction that allows compensation to be done on both sides.
That's right.
It can be financed based upon the way you said it. Not necessarily all loans, but obviously what you've looked into. It's excluded from the class actions.
That's right.
And it is a path forward as well, so that there is potentially a way to do this that avoids what the Department of Justice and a lot of these suits are targeting.
That's right.
And it's Decenture. Is it Decenture? I forget the last two letters.
It's Decenter PX. So
Decenter
property exchange.
PX. Okay.
the where people get hung up on is the British spelling of Decenter. So as I think I like to start saying it, it's decent RE, so decent real estate property exchange.
Okay. All right. So
that rolls right off the tongue.
The last minute here, I want to leave everybody on a good note. Man, we should have had some bourbon before this talk.
Yeah, I'm going to have it after.
We also should have scheduled for 2 hours, right?
Seriously. Well, we try to keep these somewhat shorter and to the point. But the biggest threats so first of all, there's going to be a path forward for agents. There'll be some carnage potential. There's going to be a lot of carnage in your scenario where this ends up going down. A lot of brokerages and companies are going to deal with
We're losing
massive
James.
litigation, and basically you've got this. There's going to be carnage there, and agents are going to come out in the ability in the long run. They're not going to get sued because they're represented by brokerages, and they'll be able to move essentially on. You think the outcome will be a separation of required compensation, so essentially
Yes.
buyer's agents paid by the buyer. And okay,
Yep.
I'm of the belief that there'll be changes in financing, so we can finance the agent's commission. I believe NAR will work on that and get that done. Keith is of the opinion that buyer broker agreements will become standard, which they should be anyway.
They should.
Yeah. And I don't think that the end of the story won't be that the buyer is paying their own commission. Maybe it's NAR solves it or helps get it solved through. Look, you could change DTI requirements and immediately you unlock it, right? So there are easier solutions than scorched earth and it's all over, or the buyer's got to write a giant check in order to purchase a house.
But the lawsuits
Yeah,
are
but-
still a big problem to
Yeah,
get
so
through,
I
as well as
totally agree.
copycat.
I'm
No,
not
there's
being
still scorched
dismissive.
earth.
Yeah.
Yeah.
I'm not being dismissive of the lawsuit and
Yeah.
and the damage that it can and probably will do.
Yeah.
Yeah.
But it would not end, that's being dramatic, but it would dramatically impact residential real estate negatively if the buyer had to pay their own commission.
But I'll close on this. I think that even after all of this, and there will be some carnage, and to what degree, who knows? I hope it's not as bad as Rob says. But I do think I genuinely believe in the long run that this industry will become more professional. I think that agents will be better at articulating their value. I think the better agents will come out and thrive. I think a lot of agents won't make it. But candidly, there's too many people representing that have the realtor badge today anyway. So, I think that it's scary, and people should be very aware of this and be paying close attention and thinking about it, because some of the stuff Rob talked about, these copycat lawsuits, that is a real threat. Like, it genuinely is a real problem. And also just do better and keep your customer focused and stay focused on what you do and what you provide, and we'll still be here. So
Yeah. And one little twist on that. I do think certainly everyone in the industry needs to have a functional knowledge of what's going on, but this is years away. I think that having an understanding is important, paying attention to it. Don't obsess over it. It's in the court's hands at this point. It's going to work its way through, whatever that means, but let's not obsess over this issue. Continue to serve your clients at the highest level.
Can I differ with you on one point, though? I agree.
Usually.
we're supposed to be
Overall,
ending the show,
no.
Rob.
Yeah, usually. Go
Well,
ahead.
so,
Go.
but this is such an important point. You're right, and I think, that's all true. However, if you are a brokerage owner,
Yes. No,
I do not
agree.
think you wait. I think you do a couple things immediately, like today.
Like what?
First of
What?
all, you call your lawyer, you figure out what your exposure is. Second of all, I think you have to immediately publish a company policy that says something about you are never to tell a seller if you don't offer enough compensation, the buyer agent won't show your house and blah, blah, blah. Like, that whole thing, because that's at
Yeah.
the heart of this.
Yeah.
As a brokerage, you got to just stop that right now, put it in an official written policy. You don't discuss that. If the seller objects to your commission, you got to overcome that commission objection some other way, other than saying, hey, if you don't offer enough, then, the other, like.
That helps stop liability
You gotta
from
do
this
that
point
right now.
forward.
Yeah.
Correct.
That's a
I
really
agree.
good. I agree
Broker,
with you.
different approach. I totally
100%.
agree.
Yeah,
Yep.
Correct.
totally agree with you.
Yep.
All right, Rob, we appreciate you so very much. It was a really thought-provoking conversation. I'm going to go get drunk now.
Yeah.
And totally kidding, but
Kidding at
it
all.
was. I'm genuinely. It's really great to hear someone really talk about this from a serious perspective. I mean this in the most loving way possible. I hope you're wrong on most of what you said.
I think it would be great for the industry if I were. I just don't think I am.
I get it.
Yeah.
And we'll look forward to having you back on as some of these things shake out.
Sure.
Because
Yep.
I think your insight and knowledge and the way you read into this stuff is just awesome. So
Always, my friends, always.
Awesome.
We do got to do that bourbon and cigar. Like, let's not have the
we'll do the
camera
next
on.
pod
We'll just,
with bourbon. So we'll do it
I'm
that
saying,
way.
let's not do a podcast. We'll just hang out and do
Yeah.
Joe Rogan. Like, bullshit, and
I'm in.
I want to hear
I'm
about
in.
Keith's beliefs on the dollar and all that. I want to hear.
Oh
all
God,
of
that's
them.
a whole
Uncle
other
Keith.
subject.
Yeah,
No,
yeah.
that one, I got a text from him at like 11 p.m. one night, and he was like, "This is the only thing I'm concerned about." And I'm like,
Yeah.
"Well, Crazy Uncle Keith isn't concerned about much of anything."
Nope.
And I read like
Very
the first
little.
3 lines, and I was like, "And I'm going to bed." So,
Yeah.
all right, we're closing out. Rob,
right.
thanks for being
All
here
right,
so
brother.
much. Appreciate
Good
it.
to see you, Rob.
Thank you, guys.
Thanks for joining us for today's podcast. Subscribe now so you never miss an episode.